very much for joining me at 4:30 on a Thursday afternoon. My name's Holly Littlewood and I am a barrister at Spire Barristers, specialising in education law and court of protection law. And the purpose of today's talk is to give an overview of the issues which may arise in the context of a young person lacking capacity in a special educational needs matter under Part 3 of the Children and Families Act 2014. Hopefully you will have received the slides in advance today. I'm sure that further copies can be circulated if anybody wants them after today's talk. And I understand that this video will be placed on YouTube as well once completed. So if you have any colleagues who might be interested, then it'll be up on there on the Spire Barristers YouTube site. Okay, so what we're going to look at today then is what are young people's decision-making rights under the Children and Families Act 2014? And how are parents involved in this decision-making process? We're then going to look at the approach where a young person's capacity may be an issue. And there are two key cases from the Upper Tribunal which guide us in that process, which are Buckinghamshire County Council and SJ, and London Borough of Hillingdon and WW. We're then going to have a look at, in a little bit more detail, how someone would go about assessing a young person's capacity. And we've got quite a recent court of protection case, a local authority and GP, which gives us some guidance on that. And there will be time for questions at the end using the chat function. So please feel free to pop any questions you have in there. I'll try and keep half an eye on it as we go through today. And we will have a look at the end as well. So to place this talk into its wider context then, and I'm sure that this will be very familiar territory for most, if not all of you, but the statutory backdrop here is Part 3 of the Children and Families Act 2014. And this sets out the new framework which replaces the old Education Act 1996 framework for identifying, assessing and supporting children and young people with SEND in England. So importantly, the Children and Families Act replaced the old statements of special educational needs with education, health and care plans. It extended the range of eligibility for EHC plans from 0 to 25. So that upper age limit increased quite significantly. And also importantly in this context, it transferred appeal rights from the child's parents to the young person. So let's have a look then at what a young person is for the purposes of the Children and Families Act. And the Children and Families Act defines a young person as someone who is over compulsory school age but under the age of 25. So compulsory school age comes to an end at the end of the academic year, so that's the last Friday in June, in which the child turns 16. And that remains the case, even though, of course, young people are in fact required to continue in education, employment or training up until their 18th birthday under the Education and Skills Act 2008. So let's have a look then at what young people's decision-making rights are under Part 3 of the Children and Families Act. Young people, so anyone over compulsory school age, can do all of these things in their own right, rather than relying on their parents to carry out these actions for them. So firstly, they can request an EHC needs assessment, and that of course is right up to their 25th birthday. They can request a review or a reassessment of their EHC plan. They can make representations in their own right about the content of that EHC plan during a review or reassessment process. They can request that a particular institution, so school or college, is named in their EHC plan. They can request a personal budget for elements of their EHC plan. They can request a mediation and can attend and participate in that. And of course, very importantly in this context, they can appeal in their own right to the SEND tribunal about decisions which concern their EHC plan. So just as a slight aside, in addition to this, the Children and Families Act also made an amendment to the Equality Act 2010, which means that a young person can also bring a claim of disability discrimination against a responsible body of a school in the SEND tribunal, and they can bring that disability discrimination claim in their own right as well. So as you can see from that list, it is a significant set of rights which is handed over from parents to young people when they reach the end of compulsory school age, which, as we've said, is around the age of 16. And this does reflect a key principle in the Children and Families Act, that young people should be as fully involved as possible in making decisions about their education. So we've seen that the rights that are handed over to young people when they reach the end of compulsory school age, but of course reaching that age should not be a cliff edge in terms of the support which young people receive in decision making from their parents and others. And of course there is a balance to be struck between promoting the autonomy of young people whilst ensuring that they receive the necessary support as they develop their decision-making skills. So the SEND Code of Practice, 0 to 25 years, gives some really useful guidance as to what the involvement of parents should be in the decision-making process. So firstly, it recognises that local authorities should help children and families prepare for this change in legal status. So it shouldn't come as a shock to anybody when children reach the end of compulsory school age and become young people. So from year 9 onwards, there is a real focus on preparation for adulthood. So we will see that through annual reviews and in terms of the outcomes that are set for young people within their EHC plan. And part of preparation for adulthood includes identification of what support is required to enable children and young people to begin to make their own decisions and to progress down that route. And as children become older, and particularly from year 9 onwards, they should become more and more closely involved in decisions which are made on their behalf. So all of that should ensure that when children reach the end of compulsory school age, there has been some preparation and planning with children and their families in terms of what's going to happen next in the decision-making process. So once a young person has reached the end of compulsory school age and they have come into their own decision-making rights, local authorities and other agencies should normally engage directly with the young person rather than their parents. And as we've said, there should be a planning process in the lead up to that. And that planning process should involve identifying the relevant people to involve in discussions and how they should be involved. And of course, all of that should be in discussion with the child and young person so that their wishes are respected and their needs are met. So in most cases of young people taking these sorts of decisions, parents will continue to be closely involved in the decision-making process. And that's, of course, particularly important for 16 and 17-year-olds for whom parents will retain parental responsibility under the Children Act 1989. So whilst the final decision will rest with the young person in all the domains that we've already identified, parents can and often do continue to support the young people in making decisions, and that could be by acting on their behalf, by attending meetings, by making phone calls, by filling in forms or making other written submissions. And it's recognised in the SEND Code of Practice that local authorities and other agencies should be flexible in recognising what sort of support the young person wants from their parents, and engaging with that process with the young person. Local authorities should also recognise that this might change over time. Ultimately, as the young person gets older, they may grow more independent and be able to make more decisions for themselves and to act more and more on their own behalf. And that also needs to be recognised and respected by the local authority and other agencies. So as young people are stepping into their decision-making rights, the SEND Code of Practice makes clear that local authorities should consider whether an independent advocate might be required for that young person to assist them in that process. And that's often something that's very useful in terms of making sure that the young person's voice and wishes and feelings are properly heard. And finally, and very importantly, the SEND Code of Practice recognises that local authorities mustn't use the views of parents as a proxy for the young person's views. Obviously, young people will have their own views on what the appropriate decision is, and local authorities should try and engage with them directly in some form or another, in order to ensure that they are receiving the young person's views and not simply the parents' views as a proxy for that. So that's the outlook of the SEND Code of Practice in terms of how parents should continue to support the decision-making process for young people, and how local authorities should help families to engage in that process. So moving on then, we've talked there about young people making their own decisions, but what if a young person's capacity is an issue? So when we talk about a young person lacking capacity or potentially lacking capacity, we do so by reference to the Mental Capacity Act 2005, and in particular Section 2 of that Act states that a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. And we will have a closer look at exactly what that means and how it's determined and assessed a little bit later on in this webinar. So when a young person's capacity may be an issue in this SEN context under Part 3 of the Children and Families Act, the main statutory provisions which we need to turn to are Section 80 of the Children and Families Act 2014, Part 6 of the Special Educational Needs and Disabilities Regulations 2014, and both of those are supplemented by Annex 1 to the SEND Code of Practice, which gives some further specific guidance. Let's have a look in a little bit more detail then about what those statutory provisions say. So where a young person lacks capacity, their decision-making rights under Part 3 of the Children and Families Act are exercisable through an alternative person acting in the young person's best interests, and that's set out in Regulation 64(1)b of the SEND regs. So an alternative person is defined as either a representative of the young person's parents where the young person doesn't have a representative, or a representative of the young person's parents where the young person's parent also lacks capacity at the relevant time and the young person doesn't have a representative. So what we have here set out in Regulation 64 is a hierarchy of alternative persons, if you like. So if the young person has a representative, and we will come on in the next slide to consider exactly what that means, because it does have a very specific meaning here, then it is that representative that will take on the decision-making rights and responsibilities of the young person rather than the young person's parents. If the young person doesn't have a representative, and again in that specific definition, which we'll come on to look at, then it's the young person's parent who will be the alternative person. If the young person's parent themselves lacks capacity, and they have a representative, and then that representative of the parent can act as alternative person. So that third type of alternative person is an exception to the general rule in the Mental Capacity Act. Section 27 of the Mental Capacity Act states that decisions which discharge parental responsibilities in matters not relating to a child's property cannot be made on a child's behalf. So seemingly Section 27 would exclude that possibility. However, Regulation 65 of the SEND regs disapplies Section 27 and means that in certain circumstances, a representative of a young person's parents can become an alternative person and bring a claim on behalf of a young person. Okay, so that was rather technical. Let's go on to have a look at what a representative means in this context, because it does have a very specific meaning outside of general usage. So pursuant to Section 86 of the Children and Families Act, a representative is either a deputy, so that is somebody appointed by the court of protection to take decisions on an individual's behalf, or an attorney, so that's somebody appointed by the individual themselves to take decisions on that individual's behalf. So I think generally it's quite unlikely that you would come across an attorney of a young person in this context. You do have to be 18 to be able to grant a power of attorney, and you have to have had capacity at the time of that grant as well. So probably an unusual set of circumstances that would bring that about in this context. You are perhaps more likely to come across a court-appointed deputy, and the deputy must be appointed to make decisions in relation to matters under Part 3 of the Children and Families Act. So what that means is that it's going to be a health and welfare deputy as opposed to a property and affairs deputy. But by far the most common scenario is that a young person doesn't have either a representative or an attorney. So we drop down to that second type of alternative person, and the young person's parent becomes the alternative person. Okay, so that's the statutory backdrop for determining what should happen where a young person lacks capacity. But how does that work in practice? We have got two upper tribunal cases. They were both heard together, in actual fact, both heard by upper tribunal Judge Jacobs in 2016, and they give guidance on the approach to capacity in the SEND tribunal. So those cases are Buckinghamshire County Council and SJ, and London Borough of Hillingdon and WW. So, Tribunal Judge Jacobs set out three different scenarios and considered each of these in turn. He looked at the situation where the young person has capacity, where the young person lacks capacity, and where capacity is an issue, and set out what the appropriate approach should be in each of those three cases. So, firstly, where the young person has capacity, so where capacity isn't in dispute and it's clear that the young person can make decisions on their own behalf in their own right, Upper Tribunal Judge Jacobs said that a young person who has capacity is in no different position from anyone else. They may appoint someone to help and act for them, and that person may be a parent or someone with some form of professional position, so for example a legal representative. And their role is as an assistant and an advocate. And when we talk about somebody acting in that role as an assistant or as an advocate, that is referred to under the first tier tribunal rules as a representative. So rather confusingly, we do see the same term, but they do have two different meanings in two different contexts. So just make sure you don't get caught out by that. So in this context, where the young person has capacity, they can appoint a representative under Rule 11, and that representative will be an assistant, an advocate, and it might be a legal representative, or it could indeed be the young person's parent, because the representative, of course, doesn't have to be legally qualified in the SEND tribunal. So if you're looking at this from a local authority perspective, you will be able to see on the form Send 35 application for an appeal if the young person has ticked the box saying that they have capacity, and if they have nominated a representative, as we say, which may well be their parents. Or if there's no representative nominated on the application for appeal, of course, it's open to the young person to appoint a representative at a later date, as long as written notice is given. And again, that's under Rule 11.2 of the First Tier Tribunal Rules. And what a representative can do in the proceedings is do anything on the young person's behalf, except of course sign a witness statement or sign the application notice if we're talking about a parent or another non-legal representative. But the key thing here is that while the young person has a representative, it's the young person themselves that remains the decision maker. They're not handing over those decision-making rights to their parents or to anybody else. Okay, so what about where the young person lacks capacity? If there's no dispute again that the young person lacks capacity, and it's clear that that's the case, and then what we have is a statutory substitution of the alternative person for the young person. So the appeal is brought by the alternative person in their name, as opposed to the name of the young person, in the best interest of the young person, and it's that alternative person who is the appellant. And again, the alternative person may act on their own, or they can use a representative in the advocacy and assistant way. So you might see a young person lacking capacity where the parent is acting as alternative person, and the parent as alternative person has instructed solicitors, for example. And Annex 1 of the Code of Practice recognises that in most cases where the young person lacks capacity, decisions are going to be taken on their behalf by their parent for the reasons we've already looked at in the previous slides, either because the parent has been appointed as health and welfare deputy, for example, or the young person has no representative and the parent has stepped in. What it's really important to note where the young person lacks capacity is that they should still be involved in the decision-making process as far as possible, and they should be supported to give their wishes and feelings and for those to be taken into account during the decision-making process. It doesn't mean that their wishes, feelings, values are set to one side. They very much should still take centre stage as part of person-centred planning. Okay, so on to the third scenario then that was considered by Upper Tribunal Judge Jacobs. If the capacity of the young person is in doubt, so it's questionable. So whether the young person has capacity is a matter of fact for the tribunal to determine, and the standard of proof is the balance of probabilities. And where it has been raised as an issue within the proceedings, it should be dealt with as a preliminary issue under Rule 5 of the First Tier Tribunal Rules. And what's likely to be required is a mental capacity assessment. So from a local authority perspective, that might be obtained from, for example, a social worker or a psychiatrist or psychologist who's already involved in the young person's care. Or, of course, an independent expert report can be sought, although they are, of course, more costly. So where capacity is in question, further to the overriding objective, the parties should draw that issue to the tribunal's attention, and they should also endeavour to provide the tribunal with any evidence that it needs in order to resolve that issue. Also, under this category of capacity questions, if we can call it that, Judge Jacob looked at the question of fluctuating capacity. So that is the case where a young person might lose and then regain their capacity over time. For example, in the case of a mental illness, that might be something that's seen. So if a young person's capacity changes during the proceedings, again, that should be brought to the attention of the first tier tribunal. And if necessary, the tribunal is empowered to substitute one party with another partway through the proceedings if necessary. So if capacity is lost or regained, then the identity of the appellant could change under Rule 9 of the first tier tribunal rules if necessary. This is a slight aside, but I did just want to flag this as an issue. Obviously, so far we've been discussing parents acting as alternative persons for incapacitated young people and taking decisions on their behalf. But there is a discrete issue in relation to deprivation of liberty for 16 or 17-year-olds, which I would just wish to flag here. So you may have a case where a 16 or 17-year-old is subject to arrangements which amount to a deprivation of liberty pursuant to Article 5 of the European Convention on Human Rights. And a deprivation of liberty is defined as having three components, just so that it's possible to identify what a deprivation of liberty is. So the first component is the objective component. That's confinement for a not negligible length of time. The second component is the subjective component, which is a lack of valid consent. So where you have a young person who lacks capacity to consent to a set of arrangements, and then you don't have valid consent, of course. And the third component is that the set of arrangements is imputable to the state. So where we're talking about education and care arrangements, of course, they will be imputable to the state. And that confinement for a not negligible period of time was further defined in Cheshire West as not free to leave and subject to continuous supervision and control. So if you have a set of arrangements where this may be the case, so for example, if the young person is going to be placed in a residential school setting, if you have a 16 or 17-year-old who lacks capacity to consent to those arrangements, the parent of the young person can't consent to those arrangements as an exercise of parental responsibility. And that was per the Supreme Court decision in Reedy. So that set of arrangements would need to be authorised by the Court of Protection. Just to further complicate matters, that will change in April 22 if and when the liberty protection safeguards come into force. And at that stage, it will be possible to authorise the deprivation of liberty of 16 and 17-year-olds and deprivations of liberty in community settings using this new liberty protection safeguards route. So that's a slight aside there, but just as we were in the context of parents making decisions on behalf of young people, I did want to flag that as a potential exception which you may come across in practice. Okay, so we've looked then at the situation where a young person potentially lacks capacity, and let's drill down now into a little bit more detail about how a young person's capacity should be assessed in this context. And what we have here in a local authority and GP is a pretty recent Court of Protection case where this very issue was considered. And in this case, the young person, GP, was a 19-year-old man with autism and severe learning difficulties. He was removed from education by his father and wasn't accessing any social care support. And the local authority were concerned by that and thought that he would benefit from continuing in education. So what the local authority did was they brought proceedings in the Court of Protection to determine whether GP had capacity to accept or to refuse an EHC needs assessment, and to make decisions more generally about his education. And this case was the first time that the Court of Protection had considered these specific questions and determined what the framework of the decisions was and what the relevant information was to those decisions. So it's a helpful judgment in that regard. And what His Honour Judge Dodd did was he began by considering the fundamental principles for assessing capacity. So I will go on to quickly go through those. It will be a bit of a whistle-stop tour due to the time limits of the webinar today, but just to give a quick overview of the fundamentals of assessing capacity in young people and others. Okay, so what we have is we have 5 key principles which are set out in Section 1 of the Mental Capacity Act. And the first 3 of those key principles relate to assessment of capacity, whereas the final 2 relate to taking a decision on a person's behalf when it has been determined that that person lacks capacity. So that's why I've put those in a different colour, just to make clear that they relate to a slightly different issue, whereas the first 3 relate to assessment of capacity. So just to quickly run through what those key principles are, and again, we don't have time, unfortunately, to go through it in any great detail. So the first principle is that a person must be assumed to have capacity unless it's established that they lack capacity. So the burden of proof is on the person asserting that that person lacks capacity, and the standard is the balance of probabilities. That said, although there is a presumption of capacity, that's not to say that if there is reason to consider that a young person might not have capacity, then that shouldn't be investigated. If there is a concern or a query as to whether a young person has capacity, then that should be explored. And the presumption of capacity certainly shouldn't be used against the young person to avoid exploring that issue in more detail if it's necessary to do so. The second key principle is that a person is not to be treated as unable to make a decision unless all practicable steps to help him to do so have been taken without success. So what that means is that a young person should be given as much support as possible to make their own decision wherever it's possible to do so. So that should involve consideration of how the relevant information is presented, in what context it's discussed, the period of time over which it's delivered. So it could be delivered over several sessions in small chunks, for example, just to give the young person every opportunity to be able to be supported to make their own decision if that is possible. Okay. The third key principle is that a person is not to be treated as unable to make a decision merely because they make an unwise decision. So they shouldn't be treated as incapacitated merely because either the agency or the person disagrees with that decision, or they don't think it's a good decision. Of course, if the young person is making a decision which is particularly unwise or irrational, and then that in itself might prompt investigation into whether the young person lacks capacity, but it shouldn't be solely on that basis that a decision as to capacity is made. So then we move on to the principles which relate to decision making for incapacitated people once the person has been found to lack capacity. So fourthly, an act done or a decision made under the Act for or on behalf of a person who lacks capacity must be done or made in their best interests. And that, of course, relates to any decisions taken by parents or other alternative people on behalf of young people who lack capacity, that any decisions made or taken must be taken in their best interests, having listened to their wishes and feelings. And finally then, the final principle is the least restrictive principle. So before the act or decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedom of action. Okay, so they're the 5 principles that should be applied, and keeping those fundamental principles in mind, this is the test as to whether a person lacks capacity. So this is under section 2 of the Mental Capacity Act. And the test is that a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. So if we break that down into 3 discrete questions or 3 steps, the first question is, can the person make the decision for themselves? And if the answer to that is no, is there a disturbance of, an impairment of or a disturbance in the functioning of the mind or brain? And finally, is there a causal link between that impairment and the inability to make the decision? So has the impairment caused the inability to make the decision? That's really important to establish that, that causal nexus. As you can see from the wording of section 2, this is a time and a decision specific test. So we are looking at the relevant decision, whatever that might be, whether it's to bring an appeal or to request an EHC needs assessment. And we're looking at that at the time it needs to be made. So there's no such thing as a general status of lacking capacity. Capacity has to be assessed in relation to a particular decision and at a particular time. It's not a status matter. Okay, so that's the test for lack of capacity, but what does it mean then to be unable to make a decision? So that's set out in section 3. And it says that a person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of the decision-making process, or to communicate his decision. And just be careful with the communication part. That's a very narrow set of circumstances where the person really has no way to communicate. So before deciding that that is the case, all practical and appropriate efforts should be made to help them communicate, looking at how they would normally do so, whether that's, for example, by sign language or whatever else. All of that should be taken into account before relying on subsection D there. So in order to determine whether someone's unable to make a decision, we need to frame the particular decision. What is the decision that needs to be taken? We need to know specifically what question we're asking, because we know that it's decision specific. And then we need to identify, well, what is the information that's relevant to that decision? What information does the young person need to be able to understand, retain, and use and weigh in order to make that decision? So turning back then to the decision in a local authority and GP, His Honour Judge Dodd looked at 2 separate aspects of decision making in the realm of education. And the first question was the decision to request an EHC needs assessment under section 36 of the Children and Families Act. And that is how His Honour Judge Dodd said that the question ought to be framed. He did reject the alternative wording proposed by the local authority, which was to request or refuse an EHC needs assessment. And His Honour Judge Dodd said, well, actually, if it's found on a statutory basis that an EHC needs assessment requires to be completed, there is no statutory basis on which the young person can refuse that. So there's no need to include a question about refusal of an EHC needs assessment in this decision. That's not to say that practically speaking, there might be circumstances where a young person refuses to engage in the process, but on a statutory interpretation level, that I think that must be correct. So His Honour Judge Dodd identified the relevant information to this decision. So the information that's set out in this slide here is what a young person must be able to understand, retain and use and weigh if they are to have capacity to decide to request an EHC needs assessment. So the information that's relevant is, firstly, that an EHC plan is a document that says what support the young person should have for their special educational needs. Secondly, that other people will be consulted during the assessment process, and the identities of the other people who may be consulted. Thirdly, that if a young person is assessed as requiring an EHC plan following an EHC needs assessment, then they will have an enforceable right to the education set out in that plan, so effectively the legal status of an EHC plan. And finally, relevant information was that an EHC plan is only available up to the age of 25 years, effectively so that a young person doesn't miss the boat by attempting to apply after their 25th birthday. The local authority contended for further information which they believed to be relevant, and that's set out in the right-hand column on the slide, which you can see. And the local authority contended that a young person should be able to understand, retain and use and weigh information that social and healthcare needs should be included, or may be included, sorry, on an EHC plan, and that may be advantageous to a young person. His Honour Judge Dodd said that that wasn't relevant information on the basis that really it didn't add a great deal to the first piece of relevant information set out at A on the left-hand side there. So the fact that the EHC plan sets out support for a young person. I think, to be perfectly honest, an EHC plan does go a bit further than special educational needs, as I'm sure you're all aware, and social care and health needs are important to an EHC plan as well. But anyway, that's the decision of the court on that point. And secondly, then it was found not to be relevant that the local authority would agree to lapse the young person's EHC plan, but that it might then be difficult to seek an EHC plan thereafter. And His Honour Judge Dodd said, well, that's really too nebulous to be relevant information. So that is the general framework then which the Court of Protection has helpfully set out for assessing whether a young person has capacity to decide whether to request an EHC needs assessment. This case also looked more generally at whether a young person had capacity to make decisions as to their education. The local authority again contended for a different framing of the question, and they wanted the assessment to be in relation to whether the young person could make decisions about his education and healthcare needs pursuant to the Children and Families Act 2014. It was found that that was too restrictive because education could be delivered outside of that framework, and that reference to healthcare needs could be confusing if it was confused perhaps with medical treatment or consent to medical treatment. So the decision was framed more generally as decisions as to education. And it was found that the relevant information for these purposes was the type of provision, the type of qualifications on offer, the cohort of pupils, and that the young person has additional rights up to the age of 25 because of his special educational needs. It was held to be too nebulous to include information as to social and personal development, or in relation to all the details of an EHC plan. And His Honour Judge Dodd stated that that would require the young person to understand and weigh the nature of social and personal development opportunities, which would place greater demands on him than others of his chronological age with unchallenged capacity. So that is the framework then for assessing whether a young person has the capacity to make decisions as to their education. And just a final note on that process generally, it was held in another course of protection case, which is B and a local authority, and that's 2019 EWCA Civ 913, if anybody needs to identify that. That the use of these sorts of guidelines is acceptable and helpful, but a note of caution, each case is fact specific, and these guidelines and this relevant and irrelevant information can and should be tailored to each specific case. So these shouldn't be applied uniformly necessarily. There has to be some thought as to the individual case that's in front of the capacity assessor. Okay, so that was a whistle-stop tour then of capacity in the context of Part 3 of the 2014 Act. And I would just like to finish by making a few practical pointers as to what might be considered in this sort of case. So firstly, I would say be alert to the issue. If you have a case either for the parents or for the local authority where the child is approaching the end of compulsory school age, and it looks like the child will reach the end of compulsory school age during the lifetime of the proceedings, it's important to consider whether it's going to be appropriate to bring that to the tribunal's attention first of all, and potentially to apply to substitute the child's parent with the young person, for example, depending on the circumstances of the case. And it may be in reality that will make little practical difference to the running or the outcome of the case. And in the Hillingdon and WW case itself, whilst it was held that the young person had capacity and was appropriately named as the applicant, Judge Jacobs did note that there was in fact no evidence to suggest any difference in the view between the young person and his mother, who was acting as representative. So in that case, the formal identification of the applicant as either the mother or the young person really made very little practical difference in terms of the running or the outcome of the case, because both the young person and the mother were speaking as one effectively. However, that won't always be the case, and that's certainly not to say that the issue should be ignored. It may well make more of a difference if, for example, the young person and the parents' views are not completely aligned. So it is important if you have a case where the child's coming up to 16, coming up to the end of compulsory school, she was given some consideration. If there is a disagreement between the parties as to whether the young person has capacity to, for example, bring proceedings, and then it's likely to require a mental capacity assessment. So as we've already discussed, that could be carried out by a professional that's already involved in the young person's care. So that could be, for example, a psychiatrist or a psychologist or a social worker. If more information is required as to that, there is a Mental Capacity Act code of practice, which gives more information as to who can carry out these capacity assessments. Equally, if it's not possible to identify an appropriate professional already involved in the young person's care, then it may need to go out to an independent expert. But of course, that does involve costs being incurred or further costs. If there's a disagreement as to the young person's capacity and you are in the SEND tribunal already, then as we've said, the first tier tribunal can consider that as a preliminary issue, and the proceedings can go from that footing. If you are operating outside of the tribunal context, so it could be in the context of an EHC needs assessment, as in the case we've just looked at, a mediation, or a request for a review, or various different things, and there is an issue as to the young person's capacity which can't be resolved, and there is an outstanding disagreement, there is always the possibility of bringing that disagreement to the Court of Protection to ask the Court of Protection to resolve it. And then thirdly, I'd just like to highlight the importance of advocacy support for young people. If there is a concern about a young person's voice being heard, do consider whether they would benefit from an independent advocate. There are various reasons why a young person might not want to get heavily involved or directly involved in, for example, tribunal proceedings. There might be some emotional or psychological impacts involved in that. It might involve sensitive discussions about the young person's needs and difficulties, or the young person might be feeling very anxious and put off by the formality of the tribunal process. So there are various reasons why a young person, even if they have capacity, might struggle to get involved in the tribunal process. And it's important in those circumstances to consider how their voice can be best put forward. That could be, as I say, by an independent advocate. It could be via a thorough exploration of their views by the relevant professionals in their case, such as the educational psychologist, social worker or speech and language therapist. But it is important that their views and their wishes and feelings are centred, and that there is a way for them to be transplanted and put into the tribunal proceedings. Okay, so that is the end of the talk. I think we're just coming up to 55 minutes, so we'll have a chance to have a look at some questions now. Thank you very much, everybody, for listening on a Thursday afternoon. If you just bear with me then, I will have a quick look through the chat now and have a read of the questions. And if anyone else has any questions, please feel free to drop them in the chat box. Or if something occurs to you at a later date, please do feel free to drop me a quick email, and my email address is there on the final slide. Okay, so I've got a question here. Often the local authorities make decisions based on added value to a young person's future outcomes. For example, if they can't show educational progression, is the provision up to 25 years dependent on progression? Do all young people on an EHCP have a right to provision up to the age of 25? Okay, that's a really good question. There's no automatic right to education right up to the age of 25. But if it's considered by the local authority that it might be appropriate to cease to maintain an education, health and care plan, then there is a formal process which must be gone through, and it must be considered whether the young person has met their educational outcomes. And if those educational outcomes are outstanding and the young person wants to remain in education, then it's highly unlikely that the young person's EHCP should be ceased to maintain. There is a specific case, which the name escapes me right now, but there is a specific case which says that qualifications and formal progress in that sense are not a necessary requirement for a young person to continue in education and to continue with an EHC plan. And it recognises that progress for a young person might look like very small steps, but nevertheless be very significant in terms of developing life and independent skills, which will go on to support them into their future adulthood. So in summary, not an automatic right, but if there is a question about ceasing to maintain an EHCP, then the case law should be looked at carefully, the relevant sections of the SEND regulations, and there's a really good section in the Code of Practice as well. Okay, I'll just have a read of the other questions. Okay, so a national trial appeal where the young person doesn't have capacity, but the mother is not a suitable alternative person, who, and the judge has stated that an independent advocate should be appointed. Okay, that isn't a situation I've come across before, actually, and it's an interesting one. I would have to probably look at the first tier tribunal regulations in a little bit more detail, and it may be the question, it may be the case that it needs to be brought to the Court of Protection to review the situation. Sorry, I'm just reading the rest of the question as well. Is it enough that... Okay, yeah. Right, so where there's a question over whether the mother is an appropriate alternative person, how is that person ruled out? That isn't something I've come across. It's a really interesting question. I will have a look at that, and it will have to be something I give a little bit more thought to, but thank you for a really thought-provoking question. Okay, okay, I've got another question here, which is, can disability such as ASD and neurodevelopmental disability be classed as, presumably classed as an impairment or disturbance in the functioning of the mind or brain? Yes, potentially. It doesn't have to be a diagnosed condition. It does have to be, as we say, a mental impairment or disturbance in the functioning of the mind or brain. So it could definitely be something such as autistic spectrum disorder or a neurodevelopmental disability. It could be significant learning disabilities, and impairments can also be temporary. So it could be something, as we've said, related to a mental illness as well. So yes, certainly those could constitute impairments for the purposes of the test. Okay, I think I've covered all the questions, and we've just come up to an hour, and it is 5:30, so I think we'll leave it there. But as I say, if anybody does want to ask anything else, please do drop me a quick line, and thank you once again for attending. I do appreciate it. Okay.